This is going to be sort of more of a discussion session than a proper reading through, but I will start by talking for about half an hour. So this is the plan. Some very quick introduction in case some of you have not been on Twitter or not been in any of the regulation discussions recently. And then I'm going to talk for about 10 to 15 minutes about the upcoming AI and UX, and then even more briefly about the digital market. And then I think we're going to have between 40 to 50 minutes of sort of open discussion about these topics. So just to say that to sort of allow us to do this a bit more concisely, when I sort of talk now, if you have any questions or some things I said that are not clear, do stop me and interrupt. But if you have like more discussion points, let's leave them yet. Okay. Great. I am only giving a pretty high level introduction of those regulatory frameworks, which are pretty in depth, but I did add quite a lot of like further reading if you guys are interested, and I will send you later. Okay. So you may have noticed that there's been quite a lot of headlines around the need to regulate AI recently, and potentially kind of this started picking up around this time. A letter that no one really here noticed, I'm sure. But specifically, there was a lot of stuff in this letter that we're not going to get into. But one thing that was kind of highlighted is that one sentence that says that we need to dramatically accelerate development of sort of robust AI governance systems. And there's been other letters. And other letters have also commented on sort of what regulation should or shouldn't do. And so this started a lot of kind of frenzy about AI regulation. And I wanted to specifically kind of pick out one quote, which I found pretty amusing, which says, that makes it imperative that governments move fast to regulate the technology appropriately and proportionately. And I just kind of wanted to highlight that fast and appropriately and proportionately kind of contradict one another, and just generally regulation is really not a fast process. So just to give examples about the EU AI Act that we're going to talk about. So the first draft, which is obviously not when they started working on it, but the first time the full draft was actually published, April 2021. The vote is upcoming tomorrow, unless it gets won. And then once it gets enforced, which will not be immediately, there is still going to be a 36-month grace period before it's actually enacted. So we are talking at the very minimum something like 5 years from idea enforcement. And I think we can talk about this now. And regulation tends to be kind of always behind. So of course, like things happen, there are potential harms, and then people start working on regulatory framework. So it's not future facing, and we can really see this in the EU AI Act as an example.
The grace period, does this mean that it has no effect for 36 months or sort of gradually comes into effect?
So it means that from the point it has started, you will not be fined as a company, not you, right? A company will not be fined for non-compliance for the first 36 months. So you have 36 months to prepare the document and things like that take things off the market. Yeah. So it's effectively in force, but it doesn't have teeth yet. Okay. So these are, and this in the next few slides, are the things I picked up from the EU's formal presentation about this piece of legislation. And this is from 2021, but the principles of this legislation haven't changed. So this is sort of their high-level reasoning about why AI needs to be regulated, which I also think is interesting because I feel like now, 2 years later, very few people are still of the opinion that AI does not need to be regulated. But still, when this came out, this is an important part of why you need to do it. And so they highlight safety risks. And I think here they mean safety risks as in component in safety mechanisms, typically in the fundamental rights, which is things around fairness and bias predominantly, and then also a lot of legal uncertainty, mistrust, are kind of highlighted as potential issues. And what is pretty interesting in this act, and this is, I think, pretty future facing, is that they have tried to make this legislation as detached as possible from the technology. So even then, it was pretty obvious that, the fast-paced nature of AI means that it's very problematic to say we're regulating this specific technology, because by the time it comes into force, nobody might use it. So they did try and take, so it says, they do say like neutral as possible. So this is supposed to cover anything that may fall under the definition of AI. And they do list in the annex a list of techniques that are in the scope, but they're not limiting the regulation itself. And the annex is much easier to update than the legislation, so this gives us flexibility of adding the technology as it comes in. So what's interesting is, so if this is not controlling for technology, how does it control for risk? And so the approach is mostly application-based. And I think this made a lot of sense at the time, but it's starting to make less sense. But let's just go over what they wanted to do. So they defined different categories. So first of all, there's unaccepted risk, which is completely prohibited. And this is sort of based on the fact that this type of risk is a risk for fundamental human rights as part of the European Union legislation, and you're not allowed to use it at all. Then they define things, categories that are high risk, and this comes with a lot of new admin. So a lot of documentation, a lot of auditing requirements, a lot of transparency requirements, a lot of work that actually right now these sectors are not ready for. And this has been fundamentally kind of going back on a lot of critical literature that's sort of highlighted risks of fairness and biases in all sorts of domains. And then they defined what's called sort of limited risks, which is permitted, but you have to have certain very basic transparency obligations, and then there's like no risk for everything else. And now what's interesting is it says not mutually exclusive. And I think this is really interesting because there's a lot of room for interpretation here, because some things that kind of fall into limited risk can also potentially be perceived as unacceptable risks. Okay, so what is, first of all, unacceptable risks? So there are several definitions. I think you will find with me that none of them is very well defined. But the first one is it's called subliminal technique. So it's basically about manipulation that may cause physical or psychological harm. Now, this means that you've interacted with technology and it affected you in a way that you did not know, and due to that, you came to harm. Now, one thing to really notice here is it does not include financial harm. So if you were somehow convinced to buy a Lexus that you didn't actually want, and you're now in debt, this actually does not fall under the definition. Okay, and then
What if you become very
this is one of the interesting things, right? Because these are not exact definitions. These are the kind of things that will eventually be determined in court. I think it depends the extent of the effect and how directly. So this is and there's another category, specifically manipulation. I'm not sure I understand the exact difference between the two things, except for the fact that in manipulation, it's about it being deliberate. So the system deliberately, or through some, design, deliberately manipulates the person. Again, cause physical or psychological harm. Again, no financial harm is in that category. So the notes here in red are not mine. They're from the link below. So there is and this is a document that if you're interested, I really recommend. It's like an expert explainer of the act. But it says specifically that this is not, so I don't know how many of you know the phrase dark matter. So this specifically means sort of ways of using personal information to manipulate somebody, usually to do for commercial purposes. So you like, this does not include in this category. So this is very, very much within manipulation, but it's predominantly to get people to buy stuff, and it's unlikely to cause them direct.
Does it have to be harm to the person who is being influenced, or like if I manipulate you into going out and shooting somebody?
So I mean, if an AI system convince you to convince, that's a good question. I think it's not something that's been like covered, and I think a lot of it is because again, the regulation tends to be like retrospective, and so it's based on things that they have seen happening, and that was not something that kind of came to light yet. 2021. Yeah. Okay. So yeah, retrospective, not clear, but potentially. I mean, I think to be determined for. Another thing that is prohibited is social scoring. I feel like this has been very much influenced from things like the Chinese credit system, and sort of the EU is sort of coming out and prohibiting any system that sort of gives you a score about home trust. Yes.
I heard this from many discussions.
Yeah.
I went back last week to China. I never heard anything like this. Personally, I don't know every score is attached to myself. I don't know what I.
Okay, hold on to that. We can get to this later because I do know quite a bit about the Chinese credit system, and I think a lot of this is because of Western misinterpretation of that system, but nonetheless, I think it had an impact.
Probably they don't care about the misinformation.
I think that's likely, but nonetheless, this perception that you can use AI to score somebody as trustworthy or not trustworthy. So, and this could be like, so, you know, this is taking something like the financial credit system, but like adding additional layers to it that are more social or potentially political rather than just purely financial.
Yeah, so maybe this is just as about what you said, but would this include something like you can't use it to score someone for a one?
For what, sorry?
For a one, because that can also be kind of like a.
So you can score for a loan as long as it's purely financial. You cannot say this person likely to have voted far right and therefore I'm not going to do it.
But so long as it is trained to predict whether or not they will repay the loan,
That's like this. Yeah. Okay. So again, this is the definition itself isn't 100% clear in terms of what's included in it. So there's a room for interpretation, but I think yeah, predominantly the financial sector is fine, but going like the step next to it is okay. And the last category is real-time remote biometrics. I'm not going to get into that because I think there's a lot here that potentially means facial recognition, but maybe not because there are exceptions, but it's those kind of. Okay. Moving on, sorry, yeah.
You said major exceptions.
Yes. Yes, there are major, like the legislation itself talks about major exceptions. In this link, they have like this whole section about this biometrics and how those exceptions. I didn't really think we would want to get into it, but it's interesting if you want to just go it.
Quick follow-up question. Is it like exceptions as in like here are the exceptions, or is it like there are major exceptions such as these?
No, there are like exceptions, you know, like
Okay.
everything
So if
here.
it's not detailed in green, it's not.
Okay, so right, so that was prohibited risk. This is not allowed under any circumstances except for the acceptance or the circumstances. But what is high risk? So high risk, just to remind you, is supposed just like you can do this, but you have a lot of diligence to do, which you have to do before you deploy, and this is pretty critical. That's the thing. You can't just deploy it and then do this admin work. You kind of have to do before. So this is the first category. So this is what's called safety components. So that will be, you know, things that mean that help planes stay in the air, or things that are part of medical devices. And basically, sort of they kind of make it safe and with anything that is AI, but is also regulated by other regulation that considers it like a potential safety component. And then it also adds 8 new categories to the high risk that are not already regulated as safety critical. And I was interested in this is based on domain of application. So again, completely technology agnostic. This could be anything from a checklist to random forest or something really much more sophisticated. It doesn't matter. So the first category is critical infrastructures. So obviously, self-driving cars and anything related to that. So anything that can potentially move in the world and hurt somebody. Biometric ID systems, passports, and other related stuff. So this is very interesting, I think. So educational and vocational training. But this doesn't mean something that is used to teach. It is something that determines a decision of whether or not you get access to education. Okay, so for example, the automated scoring of exams. I wonder what made him think of that. And anything like that. So any automated university decisions system or things like that. So this is not about it being educational, as in it's providing education, but it is about access to education as a and I think so this doesn't have to be fully automated. So this does include things like algorithm decision support system that make recommendations that a human is still making. It doesn't have to be fully automated in order to get this. Similarly, for employment, again, you can see this kind of retrospective because a lot of this has kind of had headlines related to it in the years preceding this legislation. So things like Amazon, but automated software, CV ranking, and anything to do with automated hiring. So again, fully automated, but I think it's also in scope if it does like an original like profiling and also captures into high risk. Now it is worth saying, typically with the 2 categories and some of the categories following, that these things tend to be classification predominantly. A lot of the sort of scoring, they're not, so this is really not focusing on sophistication of technology. Okay, so essential private and public services. So this is where credit scoring fits, as well as access to sort of welfare and other benefits. So this is private and public services. So benefits, again, there has been things where people have used automatic decision support system. That was not writing. To help decide who deserves benefits and who's potential benefit fraud. So this thing for the flag, and then now includes law enforcement systems, which I know a little about. So anything to do with recidivism prediction, bail, but interestingly also deepfake law enforcement detection software. Now I'm highlighting this because, as we will see, deepfake creation is actually under limited. But if you deepfake detection software, that is under high risk. But this is because this is mostly about how consequential decision making is, right? So if you go to court and you're like, look, I have evidence to say that I'm innocent, and then the police goes, no, this is deepfake, they need to be able to demonstrate that their deepfake software isn't just somebody put it in this fake packet, which that's not smart practice, you might think. Okay, so yeah, so anything to do pretty much with algorithms used by the police or the court system, although the courts is mentioned again later. Very similarly, a system used by migration assignment, border control, so things that might deny you access into a country, whether it is you just wanting to go in for a visit or you want to seek asylum. So this again is sort of it can be very different applications. So it could be the thing that verifies your that the documentation is correct, but it can also be some sort of scoring mechanism to see if you are likely to receive asylum. And again, very related to above, is administration of justice. So anything, and this is definitely not used in the UK, okay, depending how you look at it, but anything that will help sentences. So all these categories are predominantly things where people may use sort of systems to try and help make decisions, where the decisions can have very, very life-changing impact on people. And this is the main thing that influences what's being counted as high risk in this legislation. Now, I think this is relevant to mention because, again, this is 2021. So a little while ago, where people really felt that the risk was not dependent on the type of people. Now, what happens if you, yeah.
The deep fake detection, that's only for use by law enforcement.
Yes. Okay. So I'm not going to get too much into this for the sake of time, but there are a lot of there's a lot of due diligence that's required. Yes.
Seems to me that many of these questions are, I mean, it looks fine to try and limit the scope of, where it is, but, things like the right to education or something like that. Technically, if I'm screening postdocs, am I allowed to look on Google Scholar? Probably not. There's a whole lot of who knows what kind of AI that went into finding those papers and things. So I mean, if you really look at this, I mean, I'm not saying we have an automated process to figure out who to hire, but I mean, a lot of the things that we do, as a matter of course, technically,
yeah,
I would say,
yes, it's not included. So these are things that are part of formal process rather than your own individual choices of what to use based on the legislation. So you can, if you wrote down your own code, scoring and never told anyone about it, that's probably fine. But this is things that are like institutional relevant.
Part of the AI, I guess, is that it infiltrates lots of things, right?
Yes.
And so you can't really say whether did this decision in any way use an AI system. I think it's probably always going to be impossible to say.
Yes, but that still counts as, I think that, so one of the things that they don't do, and this is very true, they're not trying to say, they're not really saying that it has to be worse than the human baseline to be risky. It's just that if there is a process that used to be fully human and is now sort of routinely semi-automated, you have to do a lot of due diligence and be transparent about this application, and demonstrate that it is like done for a good reason, right? Rather than just, because you can just have a bad algorithm that saves a lot of people's time, but that's like no.
So this is only when it's part of the formal process. Like if it's just done in practice all the time, like it's never written down as part of the formal process, it's not, it doesn't follow.
That's my understanding. As everything I say here, legislation is very much part of interpretation, and for the most part, what ends up being in scope and not tends to be determined in court, but it does seem to be predominantly about formal processes. So just touching on those things that they will need to be doing, mostly because a lot of it is these sectors, definitely law enforcement, they're not ready for this. So this is very much related to my work. So algorithms used by the police, they're not being transparent about it, they're auditing it, nothing. So this will, if this is adopted in the UK, which I don't know yet, this will bring pretty significant changes into the way algorithms are incorporated into things like services, which I think is quite desirable, but this will also raise a lot of questions on the fact that some of these auditing processes are actually very theoretical. Like some of those evaluations is very difficult to do, like comparing to human baselines and judging the impact of these interventions. But it is likely coming, and it's not really preparedness, and this is why the 36 grace period, months of grace period. Okay, moving on to limits of risk. So these are specifically mentioned as limits of risk in the legislation, and limits of risk only needs to basically notify humans when they're interacting with an AI system. No other due diligence. Now, and apply a label to it. Those are the two, yeah.
So manipulation doesn't come under chatbots. So what if the chatbot manipulates you?
Right, so this is where I go back to the slide that said these are not mutually exclusive. So if a chatbot can be proven to be manipulative, it does consider it prohibited. But as a baseline, chatbots are considered limited risk. And again, this is retrospective, right? This is 2021, yeah.
How do we define a chatbot? When the chatbot start interacting with society and with the world, is that still a chatbot?
Great question. I think they haven't gotten deeply into this yet. Just very, for the sake of example, this is from yesterday, and this is from Claude, and we see some recommendation to use not very healthy sleep patterns, microdosing of drugs, and genetic editing under the recommendation. Now, to say this, that Claude did need quite a bit of like encouragement to get to the suggestions, and it did post some warning message in the end. But just to kind of highlight that, I think when they've written this legislation, there really wasn't enough thinking about the interaction. Oh, they didn't predict what chatbots are going to look like. Very. Yeah.
So related to this, I guess I heard there was a big ongoing battle about whether or not to include general purpose systems in the regulation at all. Do you know?
So they have just posted new amendments. I haven't had time to fully digest them, so I haven't presented them, but I am linking an article talking about it. I think it's making like minor changes. It's not like there is some touching into it, but it's not. It's like a band-aid, right? Rather than like they're not changing it completely. Yeah.
Sorry to slow down. Could you go back 2 slides real quick?
Yeah.
I'm just wondering, you think of any examples where labeling, so deepfakes, you wouldn't label them if they're necessary for exercise of fundamental right or freedom. Like,
So
what would that look like?
that's an excellent example. I think it's maybe like somebody that feels like the label of them would make them endanger them for some reason, like artists in countries or places where they don't feel safe. I can't really think of other examples. I feel like they just put it on to kind of say, well, if this puts somebody at risk, don't do it. But I don't think that's a very likely thing.
Yeah, it seems weird to specifically attach it to deepfakes as well, rather than like broadly if someone's in danger.
I honestly don't really know what they were thinking about deepfakes at the time, specifically because it seemed really weird to me to put deepfake detection software on the high risk. But yeah, deepfakes are fine. And I also, this doesn't consider that, this doesn't say anything about the fact that attaching a label to a deepfake doesn't mean you can't like easily remove it if you want to. It's like watermark. So there's no, I don't think there's been like a deep engagement with this technology. 2 years made a huge difference, I think, in terms of like the quality of what we produce and like the impact of that. Yeah.
So back on the general purpose system thing. So what I recall the main point of contention being is basically if somebody builds an app using GPT-4 and that app is like operating in one of these high-risk domains or something like this, and it doesn't do that, are they responsible, or is some responsibility also on?
I will get to this. This is more a DMA thing than an EU AI Act thing. So we'll talk about it.
Okay.
Yeah. This is quite fun. Okay, so fine. So what are the keys of this legislation? So this is really quite where they really did try to go big. So this is the time for prohibited use. So if you can't prove that the system has been manipulative or have caused somebody harm, now the 30 million euros is not really the scary thing here. It's 6% of the total worldwide annual turnover. That, in the case of things like Google and Microsoft, is a lot of money. So they are really trying to kind of scare people. Yeah.
You have 2 cases where you actually the 12% or is it combined?
You will have to ask the lawyer. I think you will depend if you take the report separately or not.
And does it depend if your company is based like in the EU or is it in the US maybe not accepted?
So this regulation applies to all products used in the EU. You don't have to be an EU company, but if you are deploying a service or a software in the EU, yes, you can.
What's turnover? Is that like revenue?
That's like, yeah, all over. So like no profit, all over.
Great.
The eight
Where would the funds then go to whoever was harmed by the system?
to the EU. I
Um,
believe. This is but I mean, I assume there will be some compensation, predominantly like, like the fine you pay for parking. Which puts a lot of time and money into this regulation and want to, get some back. And yeah, so this is for the prohibited. If you mess up in the high risk category, bit less, and then there's some catch-all for other non-compliance that are not high or forbidden risk. But 2% of the total worldwide annual turnover is still a lot of money if you are talking about a big company. If you're talking about a small company, then 10 million euros is all. So they're really trying to kind of,
And to be clear, none of this has actually ever gone to court yet,
this legislation is not enforced.
Not important. Are we in the grace period or are we,
No, the vote is supposed to be tomorrow.
and that's includes all this?
Yeah. So the vote is supposed to be tomorrow. Yeah.
Sorry, I missed the very beginning. So this in practice in the EU or it's now just voting for the UK?
No,
So
this is the EU vote.
Okay,
Is tomorrow.
Okay.
On this. But what I said in the beginning is, even if it does vote yes, it doesn't mean it starts that day. And even once it starts, there's a 36 grace period before companies can be taken. So this
We're
is all.
many years out from seeing this.
Yes, but I
Even if
think,
they vote yes.
yeah, but I think it is something that companies and even researchers would need to start thinking in mind, because this thing of manipulation is becoming like a pretty real risk. And so knowing that you would have to know that this is not going to happen in 3 years' time is actually not such a long-term thing. Okay, right. So if you guys are interested, I linked several further reading. I will send these slides. So the act itself, I don't recommend looking at that. The language is pretty inaccessible unless you have regulation or law background. Not sure. And then there is the 2021 presentation slide, which is the EU slide, that are sort of kind of highlighted the goals and the scope of it. There is a very good explanatory that's been posted by the LLMs Institute that kind of gives a more human language explanation about the important parts of this. And there's the last minute amendments to the act that has been put in literally a few days ago that make some differences from what I've just said, but they're not that essential. And we'll see what happens. Okay, so now I'm going to move out to the Digital Markets Act. So I think David touched on it, and I was going to say this, is that what isn't really properly worked out in this legislation, in the EAA Act, is what happens when you have like a foundation model from one company, but is actually being deployed in some high-risk setting by a different provider who ends up being responsible. And there's some things about shared responsibility, but it's not clear. And I think there is a risk that the big companies will have much better lawyers. And this being worked out in court might not end up very well. But this is where the Digital Markets Act come in. So this is also new upcoming legislation, which is not predominantly about AI, but might end up being pretty influential. So the goal is basically, this comes from competition law. So the goal is to regulate the biggest actors in the digital world, basically, and to sort of try and make sure they're not unfairly using their size to dominate the market further. So basically, it outlines what is the definition of gatekeepers. And this is a pretty narrow definition. So currently, I think only 15 or 16 companies are inside. So it's regulating very specific companies. And it sort of explains the reasoning and it gives like do's and don'ts for these gatekeepers. So here's the definition.
So the EU AI Act doesn't talk about misinformation. So if your system is spreading misinformation, they don't care about it.
It's not specifically stated. I know I'm repeating it, but this is retrospective. This is
But misinformation was also like, for example, deep fakes and everything was, they already talked about deep fakes, but the main concern was, let's say, misinformation.
but the quality of it and like the extent to which it's being used in everyday life and the impact on human life was so like this is kind of reacting to already things like academic work showing actual risk. So most of the risks that I think they're referring to, and we will see this in this lecture as well, are things that have actually happened like 5 years ago, then have been highlighted and then have been. So there's a really significant lag, which is a problem in this domain. But I think actually the DMA can help a lot. So that's all right. So this is their definition of what a gatekeeper is. And so the things I have in mind are things like Amazon, in the sense that Amazon sells things, is a platform for other businesses to sell their products. And Etsy, Google, as in Google Ads. This is kind of the mindset Apple, so operating systems, app stores, things like that, and how they've often sort of made it very difficult to people to migrate and also kind of use. So Amazon's a really good example of this. So Amazon kind of tracks what other people have been selling successfully and then launches their own one. So this is now considered like unfair advantages, and these kind of practices are going to be prohibited. And basically, I heard somebody talking about this, like Hotel California. Once you're in as a gatekeeper, you're not going out. So it's like a list. It's like a list that you go in, and then you're in this obligation, and I don't think there's but yeah, so who's in? So this is I don't actually know. I think this from an article. Sorry, I'm gonna read this out. So this is like different interpretations of who should go in and who shouldn't go in, but you can see that Google, Amazon, Microsoft, Apple, Facebook are definitely in. And then things like Uber are actually not in, but there is a lot of other like unsureness about things like Zoom, Twitter not in, Netflix not in. So even some big platforms are actually escaping this role, but a lot of the big players that might influence sort of development, sort of foundation models are in, and this is why it matters. So what is their approach? They do like basic do's and don'ts. So things that they think that these gatekeepers have to do to maintain sort of fair competitions and don'ts. Now, here's the things that I think are really relevant. So you are not allowed to reuse private data collecting through the services for the purpose of another service. So I don't need to highlight why that can make a big difference in terms of competitive advantage when it comes to foundation models. And the other thing is that you're not allowed to establish unfair conditions for business users, which brings us back to your point. So if I am the OpenAI API, that means I can't say in case of a legal breach, this is not our responsibility, because that can be counted unfair conditions of business. So like limiting accountability could actually fall under this legislation rather than the AI.
So yeah, so GPT-4 is used by somebody else to build, like, what is it, a deepfake detector or something for law enforcement. Then OpenAI could be responsible for that.
So right now, they could potentially put in the terms of service that they are not held responsible if they will end up being included under this legislation. This might not be allowed, but due to this legislation and not due to the actual AI Act. So this is really where the sort of terms and conditions between a big company and smaller users gets kind of worked out. Which is why I think it can be. So yeah, the questions will a model like an API, does that qualify as a gatekeeper? Maybe. This is where to work out. There's already one article about it. I'm also involved in writing an article about why it should be. But if it does end up falling into the scope, then this legislation, I think, adds impactful even more for this field than the actual AI. Okay, so further reading, if you're interested. So yeah, so the ZIAC itself, again, there is a 2-hour explainer video if you find yourself particularly interested. There is a regulating gatekeeper. So there's like thinking about AI in the gatekeeper sense, and this is a paper. There is also an article specifically about generative AI. And one thing I did not mention because I just thought too much is also the Digital Services Act, which is coming in and is also relevant. And sort of all of those legislations together are covered in this paper and the potential impact. Okay, that is me. I'm happy to start talking. Yeah.
Still maybe more like clarifying question, but so the Digital Markets Act, this is in effect going to be voted on at some point.
Not in effect yet. This is all upcoming. So I think one of the interesting things is that the US is also doing some regulatory, but until now, there has not really been any significant regulation of AI. GDPR was like the only starting point, but that really specifically talked about personalized, identifiable data. So where your name is attached, and you could pretty easily start like working around it once you sort of anonymize a group or turn into a thing. And this is like the first incoming, and there's 3 legislation, one go that is really trying to tackle AI directly, but none of it is actually in play.
There was already regulation in place.
So I think so. This is interesting. Again, I'm not the expert, but I know a little bit that China has a very different approach to regulating AI than Europe and so far the US, so like the West. So their approach, they already have a generative AI legislation in place, but it's a little bit different. They're basically saying, if you're deploying this, you need to tell us, and we have a right to like come and ask you questions. So it's not really like retrospective in terms of risk. It's like giving them authority to intervene without specifically saying you're not allowed to do this. It's just like give them authority over this type of.
So one of the questions is, can you just really briefly tell us what the Digital Services Act is like about?
So this is also touching on accountability around data and AI, but like on a high level and not specifically talking about bigness of big platforms. There are still holes in terms of, even when you put all these 3 legislation together, they're all about it, but it's like trying to cover different aspects. Yeah.
There's been discussion around the possible ramifications of including generative AI systems under the DNA. Because I imagine that could also lead to possible more gatekeeping if then big groups like Google, AI, etc. don't want to then release it because of the possible issues, then their groups could develop their products. Say Amazon has really good generative AI, they're not going to release because of years of this.
So this is an interesting point. So Google, Amazon, Microsoft, which now OpenAI part of, are already in the gatekeeper. And this does not, I think, affect only specific platform. I think this means that they're already, so actually adding generative AI specifically, like we're highlighting as a platform, doesn't mean that all generative AI will fall under the may just something that becomes big enough to be considered a gatekeeper. And there's some numbers, but basically you need one company to provide a service to many business users. But this can really qualify because if you're doing like software as a service for a model, you have a lot of smaller users building apps and deploying it based on the model, then it could very reasonably fall as a gatekeeper, but it's not specifically in this legislation. And I think there's polls, ours and others trying to say, oh, if you want to future-proof this, you should be thinking about it. And this is specifically because there's been other discussions that maybe you guys have heard about the potential lack of competitive advantage of companies that are developing big models because they're saying, oh, performance can be smaller, can be as good with smaller models. And then you're thinking, where does competitive advantage come from? And then a lot of it could be data, which again, so the DMA means that kind of cancels that advantage because you cannot use. So this means that if you have a lot of users running little chatbots, you cannot use the data from those chatbots to develop your model, which is because this is using other businesses' data, for your own benefit, which can really kill some of that competitive advantage.
So just a question on that. Does this only affect EU users? Like, would Google use US users' chatbot data to develop a product that they then use in the EU?
That's a great question. I'm not sure, but I think maybe yes. Or I don't know, does this impact all products that are developed in the EU? If you could potentially, maybe? I'm not sure. Yeah.
So with all this call for faster regulation, is that a thing that anyone is actually aiming to do? Is that a thing we can do? Or is this like 5-year period already got all the committees and intensive discussions with stakeholders every single day, breakneck speed?
What do you mean this?
Like, is the current process as fast as we can go? Is there a way to go faster? Is there a completely different system we should be using to have faster regulation? So the problem that we can't roll it back if we do enact it, like what's the?
I think it's a good question. The process is slow for a reason, in the sense that once you have a draft, you have a consultation, and then after the consultation, you have a vote. And then you do have to give people grace period for the most part to not disrupt their business. So it's hard to imagine it being sped up significantly. But I think what you can do is future-proof the legislation a bit better, which is not usually what they're doing. Usually they're only looking at things that happened and hazards and harms that already happened and including them. But like doing something like including foundation models as potential gatekeepers, that will kind of be more future thinking, because it is not been proven yet that they are a gatekeeper in the sense that it's not yet that there's a lot of business being generated through it because of this model, but you can kind of see that there's very reasonable future in which this comes to play. And because the competitive advantage isn't specifically on performance, you can really see how maybe like companies might have incentives to try and like fix you to their model through different types of mechanisms, and this will sort of be a preventative measure for that. Yeah.
One example that we can look at is actually financial regulation. Central banks have actually very flexible power regulating banks. It doesn't have to be a law. Sometimes it can be just a law. And we can learn from financial regulation and central labs.
I think essentially, I think one thing that like is pretty different than that is banks are very specific institutions that are have to be regulated, where most of these are still deployed by companies and maybe like even a one-person startup, and it could be potentially difficult to sort of, or you'd have to have a pretty big shift in terms of you would have to license and they be registered with like an AI operated company that will be regulated by a specific body. That is a potential route forward that might allow flexibility, but it is a big like paradigm shift from what's happening right now.
I was just gonna say something similar to other examples like the FDA as well, where just like create a regulatory agency and give it really broad sweeping powers. One of the proposals that might allow for more agility, proposed by Julian had regulatory markets. So they've been saying that we're going to have private regulators that are licensed by the government. And then you're obligated to choose one that's going to regulate you. And then the actual, sort of nitty-gritty details are being handled by private companies now. This is like, there are a few examples of this working. There may be arguably a lot of examples of it failing. One advantage I think it has is that it might enable, I should say, facilitate standardization of regulation across countries. So you have like multinational companies that are like, here's the way that we regulate, and we're going to do it the same way everywhere, maybe with some tweaks to the local context. That would make it easier to say, like, we all agree that everyone should do this.
I think something like that will definitely happen on what's in the high risk categories of AI attack, because they are talking about standardization. So giving tools a CE mark, basically, to prove you've done this work, and this usually tends to happen by external auditing bodies, and specifically like talking about something like the police. They definitely don't have the in-house capability to do running the due diligence, so you are very likely to end up either government departments or some commercial provider that says, oh, we're going to do this. And you could potentially then regulate the auditors. But how much, like how feasible it is to like scale that out to everything and where you draw the limit, that are questions to work out that I think is beyond this like I don't know.
Is there any discussion about international law for state level factors?
I think there's been polls. I definitely think that like state, like I know there's definitely like the US is looking at what the EU is doing kind of thing, but I don't think, and they're having calls for like
Yeah, I'm just wondering like how like a government would be held accountable in this setting.
Not in the moment. I think that's more like, so there are some talks around doing it specifically around autonomous weapons, like so AI-based weaponry system. So it's likely to start from that point. And if they manage to reach an agreement on that, maybe that will be the starting point.
Is this only applicable if you roll out services in EU? So that means if I'm running the service all around the world and I don't roll it out to EU, just to potentially avoid this like 6% fine on me, would that still work?
Yes. That being said, EU tends to be like the forefront of legislation. The US and other places tend to form, but like potentially things deployed only in China will be subjected to very different regulations, and it is very likely that might mean that there's, I mean, if there are markets that are big enough, yes, you might end up with something. Yeah.
And for just do we see there like any problematic regulation differences between like US and EU, or might overlap a little bit, but the EU also says like in previous documents that they really want to grow their values as big as possible, so that the UK will accept it, but obviously, I think that the China versus EU regulations are based on like different rights or different values. Do we expect there will be like major problems with that the regulation is so like contradicting, but it's such a big thing in AI, is so overlapping between these countries?
I think, I don't know. So the US is very much also trying to do like similar regulation now. I don't know how similar it's going to end up being. That's like a bit beyond my expertise, but I think they will align on major points because they are aware that most companies that operate in the US operate in the EU and vice versa. As I said, other markets, China, potentially India, might adopt very different. So far, China's been adopting very different regulation style. This will cause problems to people who want to. I mean, it's already right because there's no Google, like there's already like a lot of companies that don't operate in China.
So you said like a lot of this will start, like all the precedent will be established before, right?
Yeah.
So is there, we don't require a lot of, they'll be like actually making decisions about this requires a lot of expert knowledge. And so is there like worries about how this will actually play out? So I mean, the first few talks are like the case that actually happened, probably then establish quite a standard, but going forward. Is that
Yeah.
usually how it happens?
Yes. I mean, big cases, big famous cases that often end up at the highest courts and to set like the example of what is okay, what's not okay. And like one example is that so the use of facial recognition in the UK has sort of gone through several iterations. So it went to court, and then it went to the Court of Appeal, and it kind of got overturned several times. And this is based so I think the facial recognition is a really good example because this is based on starting point of one person suing. Now, this person was encouraged to sue by Liberty and like nonprofits, but it was based on one example of a person being wrongly arrested because of wrong like match of facial recognition. So you only need one example sometimes to be able to take the court. Yeah.
It's when humans make mistakes. Feel like a human case can't arrest the wrong person.
That's for the court to decide. I mean, that's a great question. And I think so a lot of this debate, definitely the stuff I've seen, about like law enforcement and stuff does really focus on this comparison between humans and these sort of joint system, because it's not like, if there was no bias in police and the courts originally, this would not have been migrated into the systems. So unlike a point by point comparison, you would definitely have that a person is likely to make a worse decision than on average. But because you can prove, I think, that the system makes, and because specifically like facial recognition makes more wrong decisions the darker skin that the person has, then you can sort of imagine that will be quite objectionable. I think this is also true. To be fair, this is potentially also true for people, right? We tend to have much better identification with, our brain also works with training data. But I think it's like the standardization and provability of it that makes it different. And of course, is sort of the court decides.
If the police officer was systematically arresting the wrong people as well, you'd hope there'd be some legal consequences, right?
Yes, different bills comes down to like who's liable for it. It's much easier to point the finger at a particular policeman and punish them, for example, then there's an algorithm that's like 100 people work on it. Where do you like point the finger when you can find companies, for example, that are less satisfying than maybe actually for example, pointing out that this person made an error, maybe deliberately.
But the reason these things tend to be decided in court is because it's not clear cut. It's about value. It's about value lines. It's like it happens to be that a lot of the way justice is done is that you kind of entrust high court judges to sort of reflect some sort of higher level moral view based on other institutions. But it's not like there's a clear.
One of the problems with these systems is, of course, that they're really complicated. So it's and I'm worried about. I went to this legal session at one of the NIT conferences. I was an EU lawyer that was saying, how they look at this education. They said, well, okay, there has to be transparency, and they sort of said, well, that means if an AI system has made a decision about that influences you, then you can request to know how that worked, right? And they said, okay, that means that they will have to show you the data and tell you what learning algorithm they use, right? Which is kind of bizarre, right? Everybody knows that that's not going to tell you anything, right? Although, in principle, the information might be in there somewhere, right? But so I wonder what I mean. That this is not really, it's also not really designed, I guess, for private people to get into some of these things. I mean, it's very much a sort of, it seems to be a sort of institutional thing.
Yeah. So this is a really good point. So I did some, I'm still doing some work around like the UK transparency standard, which is very much about this. Like if you have public sector algorithms, you have certain requirements, or you will have certain requirements to be transparent about these algorithms. And there's a lot of discussion about, meaning for transparency, like sensibility and stuff. And it's very true that sometimes, just giving somebody the weight is probably not going to tell them anything. It's not going to give them anything that can help them understand it the decision that's been done on them is fair. But there are other methods, right? There are counterfactual methods, for example, that can tell the person, well, if you did not have this or if you had this, then the decision, like if you can show a person what changes, what like the minimal change that would have fit the decision, I think that's a more meaningful way of like explaining things. But there's a lot, but you're absolutely right. There's a lot to work out in order for these things to really be meaningful and not just like a checklist.
Responding to your point quickly, I think the other thing that is like maybe sort of like international law is there's export controls, and I think there's an effort to like get coalitions of countries will agree to export certain hardware to certain countries like US. I have a question also, which is for the high risk ones, you mentioned that they have to do some sort of testing or evaluation before deploying the system. Is there also any obligation to do ongoing monitoring?
Yes. Yes. So the phrase is ex ante, legal point of pre-deployment, but yes, there's also the requirement.
So on the like, on the clear set of guidelines, do these things like do this like assessment stuff?
Never. I mean, this is one thing about regulation, you know, the whole profession of legal. The reason that lawyers make so much money is because this is predominantly not really legal, right? But it is not within the scope of regulation to give you a how to done. This is what grace periods are for, and this is part of what determines the market. They give you some things that you have to prove, but not how you're supposed to prove that. But I think in this case, they're sort of, they want it to be like a CE mark, so there will be a standardization, right? Like there's like a British standard of blah blah blah. So same for equipment, like some of the equipment, you will have certain tests and checks that you would have to comply to get this.
So the thing, do you imagine in the future, like 10 years, have like credit agencies just like AI, like stands, force AI? Is that gonna happen?
Probably even sooner. I think, yeah. I don't know, if people wanna, yeah, I don't know. It's up to you how long you wanna, yeah.
I have a discussion point, which is basically like, I guess I think all of this sounds good, but it's going to be like too little, too late, and it strikes me a little bit like rearranging deck chairs on the Titanic sort of thing. Like I think it's an interesting question to ask: what do we actually need here, and what's the effective way of getting it? And I guess I don't want to say this with high confidence, but recently I've been thinking that the only practical way, point of intervention, if you want to control dangerous or harmful uses of AI, is at the level of hardware. I think if we have the hardware available to build powerful systems that are dangerous, they will probably get built, and no amount of like trying to restrict how they're developed, deployed, and used is going to be sufficient. So this is more just kind of a discussion point for everyone, but I think it looks a lot more attractive than to just actually prevent people from having access to the kind of hardware, or at least I guess sort of uncontrolled access to the kind of hardware that you need. So I think all this stuff that's sort of targeting use cases, and even if we go like one step back the chain and target the development of the systems that have capabilities in the first place, I think this is like not going to be very effective.
What we're saying is that none of this legislation aims to deal with those types of risks. This is not what it's for, but it is very unusual for legislation to try and protect from future risks. So like there are pretty like fundamental questions, at the regulatory system that maybe this is like set up. And I think what's interesting is that, you know, there's a lot of people saying this is not enough, but there's also people saying actually this is too much. And this is, we're over-regulating AI already. So this is a real point of contention, and I think it's interesting, and I think it's really interesting because you're suddenly seeing so many more technical people starting to be interested and involved in regulation, which is kind of new, which is in its own will probably have an impact. But I don't know what's gonna happen. I just wanted to highlight that, yeah, these regulations are not aimed at those benefits. That's not what they're covered. So from that.
Well, I mean, they are aimed at this like subliminal manipulation or something. It's very close to it.
Yeah, but very much on like an individual.
Yes, they're aimed at applications rather than systems.
Yeah.
Now you can build a system that can do all sorts of bad stuff.
Yeah.
That's not allowed to put it in like a box
And
in user interface or something.
yeah, I'm saying this just seems like a fundamentally not very effective way of regulating things.
There's no like you can like regulate Harvard and say like you can do this in the EU, but that doesn't do it. That means the EU is just falling behind everything.
Oh, it needs to be international.
Yeah, but that's
Well, I think it will. Yeah.
That regulating the application just seems like way more.
I absolutely disagree. I mean, I think we're going to see massive proliferation of powerful systems that are extremely useful for all sorts of applications, and it's going to be like trying to prevent internet piracy, but harder. But I think, you know, maybe you can prevent big institutional actors from officially saying we do this, but you probably can't prevent everyone in that organization, both for their job, but also just all over in their daily life. We should expect to see with AI. It's massive proliferation, massive irresponsible, reckless use in every aspect of human life. And I think that regulate that effectively. I think when you start seriously, like if you take that seriously, you start thinking about how you regulate that. I think most people have observed that basically looks like a surveillance state. Surveillance is the only way that you activate using AI, developing AI, deploying AI in safe ways. And a big part of this is because, you know, you can always just use the AI system, you know, privately, and then it tells you exactly what to do. And so like you can say, well, you're not allowed to plug the AI system in. Maybe it's like somewhat easy to prevent people from actually, you know, plugging this AI system directly into the decision making loop. But you can put a human in between, or you can put some other system that obfuscates the use of the AI in between. But I think it's actually the only tractable way is the good record hardware.
One reason why, for example, the big companies is literally data mass. And so we regulate these companies where they can use this data for this sort of things. There will just be less systems available. Because I agree with you, there's always going to be something that they'll try to use. But if you don't stop the people that actually have most ability to create this,
I think maybe we'll wrap up with a formal discussion and then people who are interested. Yeah, okay.